First witness.
Today we call Pam Coalson.
You solemnly swear by the testimony you give to the court and jury on this, you nothing will be the truth, the whole truth, and nothing but the truth, so help you God.
Be seated, please.
Good afternoon. Would you please introduce yourself to the ladies and gentlemen of the jury by telling them your name and spelling it so the court reporter gets it right.
Hi, I'm Pam Coalson, P-A-M-C-O-A-L-S-O-N.
And fortunately for you, where do you work right now?
I am a retired Cobb County police officer.
Okay. So you no longer work. You're enjoying retirement.
I'm enjoying tennis, yes.
Okay. Okay, just Ms. Coalson, I guess it used to be Detective Coalson.
Yes.
How long were you with Cobb County Police?
I worked at Cobb County for 27 years.
And just kind of cutting to the chase, the last portion of your time with Cobb County Police, what unit did you work with?
I worked in the high-tech crime squad unit for my last 9 years.
And they've already heard about what high tech does. Generally, tell them what you did just on a daily basis with high tech.
Daily basis, we did forensics on computers, cell phones, any media that you would come in contact with.
Turn your attention to, well, let me ask you this. Did you have training to get to be working as a high tech detective?
Yes, I did. I took several classes in, on computers. We used a program called Encase. I took several classes on Encase. Took classes on cell phones and on-the-job training.
And can you even estimate the jury about how many different examinations or extractions you did while as a detective there?
9 years, several hundred.
Have you ever testified in court as an expert in the field of forensic examination and analysis?
Yes, I've testified as far as doing the forensics, yes.
Okay. And how many times have you been tendered as an expert, if you even remember?
I don't know if I have, but I know I've done several testimonies as far as forensics.
Okay. You testified numerous times about this.
Yes,
And is that based on your education experience and, I guess, on-the-job training doing these type of things?
yes.
Okay, Your Honor, I tender her as an expert in the field of forensic examination and analysis.
Judge, can I have one here?
No.
Just to make sure that I heard you, you're not aware of any previous case where you had been tendered as an expert in computer forensics?
I don't know if I have or not. I know I've testified in forensics, but I don't know if I've been tendered as an expert or not.
Okay.
I don't remember.
Okay. How long have you been retired?
2 years.
Okay. Congratulations.
Thank you.
In your time with the Cobb County Police Department, you said 9 years with high-tech crimes?
Yes.
Okay, so 9 years in performing the duties of a computer forensics expert?
Yes.
Okay. Judge, I don't have any.
She has to testify.
All right, Ms. Coalson, going to, back in June of 2014, were you asked to help as far as doing an extraction on a device regarding the death of a child named Cooper Harris?
Yes, I was.
And was this just one device that you actually did some work on?
Yes.
I'm going to show you what's been marked for identification purposes as State's Exhibit 303. And do you recognize this?
Yes, I do.
How do you recognize it?
From checkmark in the front, it's packaging for the MacBook Pro and my initials on the back.
And does that appear to be, is that the exact same computer that you would have done the extraction on back then in 2014?
Can I pull
Yes,
it?
absolutely. Yeah, you may need to actually pull it out of the bag to make sure.
Sorry, I have to get my glasses out to. Yes.
Your Honor, I would tender State's Exhibit 303.
Any objection?
My records indicate that it's already in that.
Actually, I think it has been admitted, Judge. tell the jury just what type of analysis you did on that computer.
On the computer, I removed the hard drive and did a bit-by-bit copy of the hard drive that was from the computer. Looked through pictures, folders, looked for deleted files, just the basic, look through the computer and see what's there.
Okay. Now, did this involve internet searches or anything like that, or is that something different that you created for other people to look at?
I did do an internet evidence finder. Once that program ran, I put it on a disk, placed it in evidence for the detective to review that information.
And when you just reviewed like documents, things like that, did you find anything of note on that computer as far as documents and just things of that nature?
No, I did not.
Okay. And the actual computer, I guess, internet evidence finder, you left that to the detectives to actually go through and see if there was anything relevant, correct?
Yes, I did.
I'm going to show you what I marked for identification purposes in State's Exhibit 322. Yeah. Okay, detective showing you State's Exhibit 322. Do you recognize this?
Yes, that's the disc that I produced and placed in evidence.
Okay, how can you tell that it's yours?
My initials and bad handwriting.
Your Honor, I would tender State's Exhibit 322 at this time.
No objection, subject to the issues in the present folder.
Same objection, whatever said rule.
That's all I have, Judge.
Cross.
Your responsibility in this case was to perform the duties of a computer forensics expert for the Cobb County Police Department for one device.
Yes.
And that one device was the Apple MacBook Pro.
Yes.
Okay. And that Apple MacBook Pro, your understanding is different than Leanna Harris's Apple MacBook Pro that someone else with your unit examined. This one was specifically Ross Harris's, correct?
That's correct.
Do you have your report?
Yes, I do.
Okay. And because you only worked on one device, you don't have many reports in this case, correct?
Just this report, yes.
And you reviewed those reports before testifying today?
This report, yes.
Okay. You prepped with the district attorney's office,
Yes.
correct? Fair to say that having been retired for a couple of years, perhaps your memory about your work in this case has faded over time?
Oh, well, yes. I mean, that's why I reviewed them.
That's why you, okay. And you needed them, right, to refresh your memory about what you did?
Yes.
Now, you assisted Detective Yeager with the analysis of this computer, the Apple MacBook Pro.
Yes, he asked me to do this computer.
Okay. Now, is there a chain of command within your unit where Detective Yeager would have been responsible for delegating responsibilities like that?
Yeah, we worked as a team.
Okay.
In any case that had a lot of computer cell phones, we'd assist each other.
Now, is this the kind of case that you would consider as having a lot of computer devices or electronic devices?
anytime you're dealing with computers or cell phones, anything over 2 is a lot. It can take time. When you're looking at 500 gigabytes in a computer, that takes time. So,
And in your 9 years with this unit, having close to a dozen electronic devices, that's a significant amount, correct?
yes,
Ross Harris was a web developer. Do you know that?
if you say so. I don't know anything about Mr. Harris.
You don't know anything about the investigation?
Process this computer, that's really all I know about Mr. Harris.
Okay.
But he works at Home Depot, that's all I know.
Fair to say, though, that in high-tech crimes, you can learn a lot about a person about their activity on their electronic devices.
That's true.
Okay? And that was your function, is to look at this computer, correct?
That's correct.
Now, you were specifically informed of the allegation that Ross Harris had researched on the internet. He and his wife had allegedly researched on the internet, or told detectives that they had researched on the internet in-car deaths, correct?
I was told from their interview, I mean, not exact, but I was told from their interview that it was mentioned about car deaths.
Okay,
I checked the computer for that. I can't give you verbatim what the detectives told me 2 years ago, but they'd learned in an interview that they had done searches for that.
Well, to the best of your memory, what did detectives tell you to assist you in what to look for on these devices?
They wanted internet history, which I provided,
Okay.
and anything related to the crimes of murder and car deaths.
And in your report, you specifically indicate a search warrant, right? Because in order to go into a device, you got to have a search warrant.
That's
Right?
correct.
And the search warrant sets parameters, sets limits of what you can look at and what you can't, right?
That's correct.
And in this case, you were told to look for evidence that would be relevant to murder, correct?
Correct.
Cruelty to children,
Correct.
okay? And then specifically, because you mentioned having to rely on this search warrant, 14 SW 0609, you were informed that allegedly Ross stated that he recently researched through the internet child deaths inside vehicles and what temperature it needs to be for that to occur, correct?
Okay, yes.
That's right. And so in specifically crafting your examination and analysis of this computer, you're able to, in fact, you reviewed, searched internet history, documents, and a keyword search. What were the keyword searches that you performed?
Well, the keyword searches would have been, it'll be on the actual report that it should have been murder, child cruelty. Simple word is child. Cruelty, you're going to break that down to look up different ways of,
It should be on this report,
that I believe is
the IEF.
that is the, well, that's the Internet Evidence Finder.
Okay, so what report contains the keyword search terms that you use to examine that computer?
That would be on the hard drive that has the evidence files on it. There was no report produced on this because there was no notable files found. The Internet Evidence Finder, that was downloaded, placed on that disk for the detective to review. I didn't locate any notable files as far as child and murder, car deaths, so there was no report generated. But there is evidence files.
Well, what I'm asking is, what report has the keyword search terms that you use to examine and analyze that computer?
Answering your question, there was no report generated on that. There is evidence files, but there was no report generated. The only report that was generated was the Internet Evidence Finder, which was provided to the detective for his review.
So how do we find out exactly what keyword searches you use to examine the Apple MacBook Pro?
We'd have to bring up the evidence files.
And where are those?
They're probably at a high-tech crime unit as a backup.
They're in Cobb?
I'm assuming. I don't have them with me now.
So you didn't review those evidence files before testifying?
I reviewed my report here, like I say. I found no notable files, so a report was not generated on what I did on the forensics. I know you want specifically what did I look for?
Sure. And we'll get to what you
Child,
found.
car deaths.
We'll get to what you found. I'm specifically asking, how do we find out? How does the jury understand what search terms you use?
Objection, asked and answered a few times, Judge.
I know I've asked it several times, Judge, but it hasn't been answered. She's told me that no notable files were found. That's not my question. We're going to get to that. I'm asking about the keyword search terms that she used to examine the computer.
Well, she has testified to that, so I sustain the objection.
Thank you.
You searched for murder, cruelty to children. Okay. Do you remember anything else?
No, I do not.
Okay. Having been advised that Ross had allegedly researched through the internet in-car deaths, naturally you would have searched for that, right?
That's why I did the Internet Evidence Finder and downloaded that to a file for the detective to review. They're familiar with the case, so that was sent to him or her to interview. To look through the report.
Now, but you go through it as well, right? You examine and you look through the Internet Evidence Finder program, right?
On this particular, no. That file was ran. It was placed on a disk and placed in evidence for detective review. They know what they're looking for specific. On computers, with pictures and all, there's a lot of pictures you can have on the computer. So yes, we'll assist and we'll go through those because, that's kind of hard to put on the disk. 500, that's a lot to keep doing this. But Internet Evidence Finder, they can put that in, they can look through, they know what they're looking for, and they can find what they need.
The report you created, you didn't go through?
As I stated, I ran the program. I downloaded it to that disk once the program completed. I placed that disk on a property control record. It was placed in evidence for detective review. Detective knew what he was looking for. They can look through that portion of the evidence.
Okay. Did you not know what you were looking for?
Once again, they know the specifics of what they're looking for. I could use my time better to go through, look at pictures through the internet, because like I say, that's a lot to put on disk when you got 500 gigabytes of items that you're going through. That's a lot for them to put on disk for them to look at. They want even in an Internet Evidence Finder, I place it on a disk, they review it for their evidence.
The following is a list of items that you reviewed and searched during your analysis.
Objection, Judge. That's misstating what it says. It says and or.
You want to rephrase?
Sure. The following is a list of items reviewed and or searched during the analysis. Recovered folders for each volume, correct?
Correct.
Sweep case, correct? File structure for compound compressed files, correct?
Yes.
Gallery review, that includes JPEGs or photos and videos, correct?
Correct.
internet history, correct?
Correct.
Document review, correct?
Correct.
And IEF, Internet Evidence Finder, reported, placed in an HTML report. That's this, correct?
That's correct.
Right. And according to your report, you reviewed and/or searched this item.
According to the report, what you just stated, placed in an HTML report, and/or that was placed in an HTML report and was later placed on property control record 250429 for detective review.
This is one of the things that you listed as having searched and/or reviewed, correct?
Look at the report, it says placed in an HTML report, and/or, I don't know how to answer your question.
It's very simple. You reviewed that report because
No, I
your
did
report
not.
says that.
I did not review that report. I told you. I downloaded it, put it on a disk. It was for the detective review. I don't know what's on there. Unless it was in some kind of gallery review when I was looking at the computer, then I would have seen some of the things that may or may not be on that disk. I don't know what's on that disk.
When you write a report, in 9 years, it's your experience to be accurate, correct?
I feel that I was very accurate in what I reported there.
Your conclusion is that during the analysis, you did not locate any notable files. Your testimony is that you did not look through this, correct?
That's correct.
Yet your report says that you did, and there were no notable files of interest inside of it.
My report does not say that.
Okay. Let me get a clean copy.
Here you go.
Full report.
Oh, I got the third page. Here you go. Sorry.
Judge, I'm showing the state what's been pre-marked for identification purposes as defendants 34. This is your report, correct?
That's correct.
Is that a fair and accurate copy of the report you generated in this case?
Yes, but I didn't highlight the numbers, the dates that you have highlighted.
The content of these is not any different from the content of your report that you're holding in your hand, correct?
That's correct.
I'm going to move D34.
No objection.
After running keyword searches on this computer, you found no notable files. Permission to publish?
First of all, I'm going to object because that wasn't a question. You just made a statement and tried to tender something or publish something. So I'm going to object to the question. It's not a question.
Sustained testimony.
You'd agree that the last item that you reviewed and/or searched during the analysis in your report is a keyword search.
That's in the list. Yes, it's in the list. It's the last thing on the list.
And the results of your forensic analysis is that you did not locate
personally, I did not locate any notable files
On the Apple MacBook Pro.
on the Apple MacBook Pro.
Ross's personal computer, correct? If there was pornography on that computer, it wasn't notable to you.
I wasn't aware that I was looking for pornography, but no, it was not notable to me.
You looked through it. You found no notable files.
That was not notable to me. That is why I provide the detective with the Internet Evidence Finder so he can find his notable files. They know what they're looking for. I get a general idea of what they're looking for, but they know best what they're looking for as far as the Internet, because that was of interest.
Just a second.
Nothing further, may she be excused.
Yes, you're free to go. Next witness.
State calls Danielle Abdur. Ma'am, would you introduce yourself to the ladies and gentlemen of the jury by telling them your name and spelling it so the court reporter gets it correct?
My name is Danielle Durr, and you spell it D-A-N-I-E-L-A-D-O-E-R-R.
Okay. And Ms. Durr, without telling us your exact address, where do you live generally?
I live in Ackworth.
Okay. We're down here in the south of South Georgia. Tell the jury where Ackworth is, what county it's in.
Ackworth is actually considered Cherokee. It's in the Tri-County area. It's about an hour away from Atlanta on the north side.
Is it near Cobb County?
Yes,
It's part of Ackworth actually in Cobb County.
it's Tri-County area.
All right. Back in 2014 in June, where were you living?
I live in Marietta on Franklin Road.
And were you living in Franklin Road?
Yes, I was. I was staying at the Econo Lodge.
Okay. Now, not meant to embarrass you or anything, but tell the jury what kind of work you were doing back in May, June 2014.
Due to unseeable circumstances, I had to associate myself with Backpage in order to make it to where I am now.
Now, our jurors may not know what Backpage is, but...
It is an escort service.
And as an escort, did you perform sexual acts for money back then?
Yes, I did.
Okay. I'm going to turn your attention well, first let's start with Backpage. Are there different types of sites that you could use back then when you were having to do this to advertise?
I struck strictly to Backpage.
Okay.
I wasn't really aware this was my first time actually doing anything of that nature as far as going on the internet and publicly advertising something that way. That was the only site that I knew of.
Now, when you advertised on this website, did you actually post a phone number?
Yes, I did.
Do you remember that exactly off the top of your head?
Not the last 4 digits. I'm familiar with the 678.
Okay. If I showed you a copy of a report, would that refresh your recollection? If you saw the number, would it remind you if it was yours or not? Okay. Please. You talked about a 678 number. Let me let you look at this real quick. Looking at that, does that refresh your recollection about what number you were and what number were you using back then?
I was using that number that was posted with my ad. That was the only phone number I had.
Okay, just for the record, that is 678-360-0318.
Yes, sir.
Okay. So tell the jury a little bit how that would work when you posted your phone number on an advertisement.
Initially, my number would go on the ad with a couple of pictures, just a couple of face shots, just to let it be known that it was me, along with a number that allowed the person, whoever needed the service, as it was put kindly, they would call me. They would come to me. I would not do outcalls, which is where you go to the person, meet up in their environment. That was something I didn't engage in. It was very
sketchy already given the circumstances of the business. So with my phone number, that was a way for you to contact me, to come to me, so that I could feel at least somewhat dignity or comfort doing what I was doing. So.
Now, during this time when you were doing this, let me go ahead and jump to September of 2014. Did you get a call to respond to a hotel, and you showed up and it wasn't what you thought it was going to be?
Actually, I got a call, and I told them on the call that they had come to me, and they actually did come to me.
Okay.
So.
Okay. And in September of 2014, who showed up?
Initially, it was a Hispanic gentleman, and the Hispanic gentleman told me that he had left the money in his car, and we proceeded to go to the door, and that's when I figured out what the real reason was.
Was it the police?
Yes, there was an armed officer at the door.
Okay. So obviously, when this happened, were you afraid you're about to be busted?
My words were, I'm going to jail.
Okay. Were you on probation at the time?
Yes, I was.
Okay. Now, when they approached you, first of all, did they talk to you about, did they say they were going to arrest you for the prostitution? Or,
No.
okay.
They did tell me that it was pretty much a ruse just to get to me, to talk to me, because apparently my number had been seen in the cell phone or whichever records that had acquired my number on it. They did ask me if anything was in the room that I shouldn't have, and I openly admitted that I did have marijuana. They never saw the marijuana, but clearly from the smell of the room, you knew I had it. So there was no reason to lie.
Mm-hmm.
But there was no, you're going to go to jail if you don't talk to us or anything like that. It was, this is how we got to you. Now can we talk to you?
Okay. Did you agree to speak with them?
Yes, I did.
Okay.
Being on probation and knowing the situation I had myself in, the best bet for me was to be cooperative.
Did they in any way, did they tell you what the focus of their investigation was? Like what type of crime they were investigating or anything like that? Or were they just interested in a specific person, if you knew?
They asked me if I had seen this person. They showed me just the face shot. And automatically I knew what it was because clearly by that point it had been on the news. I really hadn't watched the news too tough.
Mm-hmm.
You know, I had heard fleeting rumors and hearsay gossip about what was going on, but as soon as I saw the picture and it was like, yeah, I had seen him a couple of times, that's when the broad scheme of what was going on had came to play.
Okay. So the first part when you recognized him, was it because of your interactions with him in May personally?
Of course.
Okay. And then later you kind of realized what it was?
Yes.
Okay. I'm going to show defense counsel marked for identification purposes the state's exhibit 323. Showing you state's exhibit 323, do you recognize that?
That was the picture.
Okay. Does that look similar to the picture they showed you?
Yep.
Your Honor, it's under state's exhibit 323.
Objection based on our subsequent motions in this matter.
All right. Allowed over objection. Our ruling stands.
Thank you. Just permission to publish brief.
You may.
Thank you. Now, when they showed you this picture, did you immediately say, that you thought you recognized this guy?
I was very confident that I recognized him.
Did you give him a percentage at the time?
Oh, yes.
What was
I
it?
was at least 90% sure because
And was this, let me ask you this, was this before verifying any phone numbers or anything like that?
oh yes, most definitely.
Okay. When they showed you this photograph, did you tell them about encountering him back in May of 2014?
I knew exactly who he was once I looked into the picture and they started telling me because he actually came to me the week of my birthday, which is in May.
And as far as this sticking out to you, let's start, what hotel did you work out of back in May?
Nikon Lodge.
Okay. And back in May of 2014, do you, why did he stick out amongst everybody else? Is there something different about him than most of the people that you would see?
It's not that. It's more or less in that business, you have a memory. You can't block it out unless you just completely lose your whole self in that. And on a personal note, I do not prefer white men, so they do. I have to remember that.
Okay. So you usually were, engaging in these things with African American males?
Yes.
Okay, so did he stick out because he was a white guy?
Not only that, but just given the circumstances of hearing everything and then going back to those 3 times that I saw him beforehand, there was never any nervousness. It was always like he was very relaxed. Nothing was ever going on. He really didn't talk about much. It was more or less strictly business and then go on your way.
And when you saw this picture, did you describe to the police or describe to the jury what you remember about what happened? What type of acts and things like that?
It was basically regular vanilla sex, no crazy fetishes, no nothing. The first time I remember clearly was a quick visit, which is 15 minutes, just to grab bearing of who you are and who I am, to make sure I'm not a police officer or it's not a sting. The second time was actually a little bit longer, 30 minutes. The reason the way I was able to describe him was just, he didn't have any presence about himself, like he just didn't care, very dumpy, just, a little bit overweight, a little bit on the hefty side, just really didn't care about his appearance. You can just tell.
Now, when you have something like this, when you have a person that comes to you for these services, are there any usual amount of times or contacts that you have with the person before they come to the room?
Mainly it's minimal contact. It's mainly just where I'm at, where you are. It's very quick sort of questioning, no affiliation. At the end, it's still based upon them coming to your room or you going to them, which in my case was not an option.
Do you remember how many times he would have called you before he would have arrived?
He called
If
me.
you do.
If he texted me the first time and asked me, hey, are you available? And I would tell him yes or no. And then he called me to let me know that he was there, because at the Econo Lodge you actually had to be, you had to stay there in order to get in. You had to have a key card. So I had to let him in because I had to walk to the end of the corridor to let him in from the outside. So I would get called at least twice. Once to ask if I was available, second time to let me know when they were there so I could let them in.
Okay. Did you actually engage in sexual acts with him back in May?
Yes, on 3 different occasions.
Okay. Now, were you actually asked to look up, or did you volunteer to look up the phone number that they gave you for him?
I did at the time.
For a May 31st incident?
I did. I had Sprint at the time, so I was able to pull up my phone bill directly on my phone, and I highlighted every time he called my phone.
Did they give you a number, and did you look at it and verify you had gotten that?
Yes, we verified it between my phone bill and what they showed me.
Now, I know it's been a couple years since you went through this. You've gone through some stuff in your life. Okay. When you talked to the police back in 2014, do you think your memory would have been better then or better now today? It's maybe a tough question, but
Honestly, I would have to say it'd be about the same because,
Okay.
Since that point in my life, I've done nothing but get better. I became a mother myself, finally. My daughter was born 3 months early, so I've gone through a lot of different good things. So, I try not to think about back then, but I keep a hold of that because it shows me what I overcame.
and with all this, with everything you've said about this, the police actually came to you with his phone number, right?
Yes.
And they saw verified on your bill that it was his
Yes.
number that contacted you, right?
Yes.
Okay, that's all I have. Thank you.
Hey, good afternoon, Ms. Dorr. Am I pronouncing that correctly? Durr. Okay, sorry. All right, so I first want to ask you a little bit about your using Backpage. Is this is it a written newspaper or is it an online
It's
newspaper?
an online ad.
Okay. How long had you been using Backpage?
By the time that they came and saw me, it only had been since April, end of March, beginning of April, that had just gotten down to Cobb County.
Okay. March or April of 2014?
Mm-hmm.
Okay. All right. And I think you said it was your birthday?
The week of my birthday, yes.
Okay. All right, do you remember going over your phone logs with them that it was May the 31st of 2014?
I'm not completely sure about the date.
Okay. May have been end of May?
I know it was definitely in May.
Okay.
And the first time he did see me was the week of my birthday,
Which is when?
May 18th.
Okay. And when you said first time he saw you, you said it was 15 minutes?
Yes.
And this would have been the week of May the 18th?
Yes.
And was it the same location at the Econo Lodge?
Yes.
Okay. And the only way that he would be able to locate you was your phone number on the back page?
Yes.
Okay.
Because before then, I had never seen him a day in my life. I'm not even from the area.
All right. So, did you take a look at your phone record to see if the same number was on the 18th?
Yes, it did.
Okay. And so you said that was 15 minutes, and then the next time you saw him was when?
30 minutes. I'm not sure about the second time. I just remember the first time specifically because when I was talking with him, that was what stood out because of that week of my birthday.
All right. And you talk to people regularly without actually having a date with them, right?
Back then, you had people call you and ask questions.
Sure.
You had a lot of people no-show. Sure.
Sure. Or shopping around.
Yeah.
See what you were into, how much you would charge, what
Yes.
the circumstances were, just sort of feel you out.
Generally, it wasn't really discussed on the phone because, never knew what was on the other line. So that kind of information, you just really didn't give out.
Right. But the bottom line is just because someone's phone number appeared on your bill doesn't mean you necessarily met with them that day.
You can make that assumption, yes.
Okay. And you kind of had a little procedure where if you were actually going to meet with somebody, there would be multiple calls right together, right?
Not multiple. You would call me the first time, you would
Okay.
set up your appointment, and the second time would be when you would get there. So it really wasn't multiple times unless you just got lost or you didn't know where you were going.
Okay. So what kind of direction did you give your customers?
I sent them the address so you can GPS it.
Okay. And do you tell them when they get to the motel
To call me.
that they're to call you?
Yes.
Right. Just once.
Yes.
Right. There's not a second call?
There's 2 calls in total. The first time when you call me to set up the appointment.
Right.
The second time would be when you would get there, so I had to let you in because you couldn't get in. It was not a free access hotel.
All right. Were you working any other motels besides the Econo Lodge?
For a momentary stay, I had worked at the one across the street, but
Ramada?
I believe that was the name at the time.
Okay.
They've not changed it so
Right.
many times.
All right. That was the, and it's off of Franklin Road.
It's right across the street from the Econo. They were doing
Okay.
renovations at one point, and I had stayed over there for a couple of days and went right back to the Econo.
All right. So when you were working the Ramada, if your customers called, you would direct them to that motel.
Yes.
All right. And you think you've been working Cobb County since March or April of 2014?
At that time, yeah, it was.
Okay. And prior to that, you were from the Rome, Floyd County area?
Bartow.
Bartow. All right. And what motel were you working in Bartow County?
I didn't work up there.
You weren't working there? Okay.
That was a choice I made after, some things had happened and I had lost everything that I owned. That was a way for me to survive, not having any family in the United States.
Okay. How did you learn how to post an ad on Backpage? Did you have a laptop or something and just started
Phone.
investigating it?
I had a phone, word of mouth, by the time I got down to that area, just figured I'd try it, give it a shot.
Well, I don't know, and that's why I'm asking. Did you
It was
have
my mouth.
some other friends who were in the same business?
I had one female friend that was in the same business, but she's not the one who taught me about it. Like I said, I had heard through it word of mouth, and it was a decision I made on my own.
Okay. So you were just sort of self-taught how to get online or get on the phone and place the ad on Backpage.
Pretty much I figured out how to do it by myself.
All right. And was it always the same ad? I mean,
Yes.
did it look the same? Did you change it up any?
No, not that late. That was one, that's one thing you kind of had to keep in mind back then. If you keep changing it, people would be sketchy to come see you.
Okay. Well, did you have regular, did you have regular customers then that, I mean, they had your phone number, so, they would come on a regular basis?
Yes.
Right. How many regular customers did you think you may have had?
Not a clue.
No. Okay.
I did what I did to survive, not I agreed, so it's not like I took
I'm
everybody
not
that came to
judging
me.
you. I'm not judging you, okay.
I didn't take every caller that came to me. I did what I needed to make sure that I was okay.
Okay. And all right, during this time period, and again, this isn't meant to embarrass you or anything, but just to kind of give us an idea. I mean, how much work were you doing? A couple of customers a day or something like that?
I would have a goal of at least 3 or 4 a day to make sure that I could pay for my room and be fed and take care of my personal belongings. So I said I didn't do it with greed intentions.
Okay.
I did it solely and based upon what I needed for the day or for the week, however I planned it.
All right. And did you always do it at 30-minute blocks of time?
No, I did 50. You had a choice of either 15 minutes, 30 minutes, or a whole hour. It was depending on what you paid for.
Okay. And most of the time, is it fair to say it was usually half hour?
Most of the time, it was actually quick visits. That was generally the money maker, as you should say.
Right. Okay. And the half hour was $1.25.
Yes.
$125.
Yes.
Okay. And I'm assuming you just took cash? All right. All right. And your recollection, you said it was strictly business and on his way.
Yes.
All right. We're just talking about sex.
Yes.
Okay.
I'm not your psychiatrist. I'm not your therapist. You came to see me normally because your wife wouldn't shut up.
Right. We're not talking about the girlfriend experience.
Exactly. I didn't want to know about your kids. Didn't want to know about nothing. You came in, you got your pleasures, your jollies, and you went about your life.
All right. And well said. And I assume that you probably had customers in all walks of life in that area.
Most definitely.
And when that area, that's right off of Interstate 75.
Oh, yeah. You got every religion, every race, every color, everything.
Right.
So,
I know that must have been difficult, to say the least, but you saw across a wide spectrum of men,
yes.
white and black,
Yes.
younger and older,
Yeah.
and middle-aged like me.
Yes. That was the prime retail.
That's the problem.
That was the prime retail.
Because they were working age and they had money.
That and they had been in a relationship for a while, and stress, and I guess after 10 years or 15 years, y'all go back your way.
7-year itch.
Pretty much.
Okay.
That's what you could say.
And that was your job. You were there to do that business,
Yeah.
and you had plenty of customers that came through the door.
Yes.
Okay. Working guys, blue collar, that had $125. And guys like me in suits.
Most definitely.
Okay. And everybody in between.
Yeah.
Okay. And other than the fact that he was white, I mean, there was nothing particularly remarkable about him.
No, I mean, like I said, not only because of the fact that he had been a repeat, and repeats tend to stick out a little bit more, it just, like I said, he just took no care in his appearance. Certain things like that, being how I am, OCD as far as like appearance-wise and cleanliness-wise, those are things that do stick out to me.
Okay. You told us you were on probation at the time.
Yes, I was.
All right. And was that for marijuana?
Yes.
All right. Bartow County? You were on probation in Bartow County?
Yes.
At that time?
Yes.
Okay. And the officers that came in, they let you know right off the bat they knew you were on probation?
No, they didn't say that.
They did not?
No.
Okay.
But like I said, being in the situation that I was, when the question was asked, do you have anything in here you shouldn't have, there's no sense to lie, and the smell gave me away.
All right, all right. The smell being marijuana?
Mhm.
All right. Did you have marijuana out on the table that you were
They never saw it.
smoking? They never saw it?
No.
All right. What did you say about the marijuana
I
smell?
just said that I had, when they asked me if I had anything in the room that I was not supposed to have, I let them know.
All right.
So don't think that answer.
And you let them know. You said, hey, I got some weed in here. And did they ask to see it?
No.
They just said,
I think the
That's
main
no
question
questions
was
with taking them?
basically to ensure that I didn't have any weapons or firearms in the room, which I didn't.
okay. Bottom line is, they knew you had weed, and they didn't ask to see it, and they didn't see it. Okay, they left your apartment, and they left the weed behind.
Mhm.
Okay. And I'm sure at that time you were breathing a big,
I shut down business the rest of the night. Let's just say we sat in the bed and we was a nice little country girl and just sat and watched TV all day.
yeah.
That kind of.
It scared you?
Yes, it did. It shell shocked me. I'm not even gonna lie.
When did you, you're not doing this anymore?
No.
Okay. When were you able to get out of this?
Yes.
When?
Oh, and I actually found out I was pregnant right after the officers came and saw me. Not even 2 or 3 weeks later, I found out I was pregnant. And given my history with pregnancy, I gave it all up.
Okay.
I got out of town.
Good for you. All right. Did you drive down here today?
Yes.
Okay.
No, I drove down yesterday.
You drove down yesterday?
Yes, I took that nice little 5.5 hour trip.
Okay. And they were nice enough to get you a hotel and all that?
Yes.
All right. You're gonna turn around and go back today?
I'd like to. I want to go back to my
Did-
baby.
All right. Did you bring you didn't bring your baby with you?
No. I
Okay.
said I don't want to. No.
I think that's all.
She's almost 2. Would you bring her? Yeah.
Mine's 15. I think that's all I have. Best of luck to you.
Thank you.
I mean that.
One follow-up, Judge. Ma'am, do you recognize the person that you were talking about when you talked to the police and described having sex for money with him back in May of 2014 in the courtroom here today?
Yes, I do.
Okay, can you point to him about what he's wearing and
He's wearing the green suit in the middle between the two gentlemen right there.
Your Honor, has the record reflect that she has identified the defendant in this case?
Right in the silver glove.
Thank you.
Judge, if I can make just one.
Yes.
Let me just clarify one thing. You said that, you said that there was a Hispanic man who came to the door initially, and that was the date.
That was the date, yes.
Okay, and then y'all walked to the door and the gig was up. There were uniformed officers out there.
And there was one uniformed officer and then another officer.
Okay.
So there was 3 in total. There was 3 officers in total that came to my room.
All right. One being the Hispanic
Yes.
guy, second being the uniformed officer, and then there was a second officer outside.
Yes.
All right.
Once I saw the uniform, I knew right then and there. Well, I assumed right then and there I was gone.
Okay. And I'm assuming we all have a little conversation there in your apartment. All 3 officers were inside the apartment.
Yes.
So all 3 would have heard the conversation and what was going on.
Yep.
Which officer told you that he wasn't going to take your weed?
The Hispanic gentleman let me know that, hey, yeah, we're the police, but we're not that kind of police. We're here on 2 totally different, You don't have nothing to do with that. We would like to talk to you.
But he very specifically told you,
I'm not going to jail. You're not going to jail today for prostitution. Yes.
and I'm not gonna take your marijuana.
I mean, they never saw it. They never even asked to see it. I mean, I was very forthcoming with everything I had to say and what I needed to do.
Okay.
Anything further?
No, Judge, but she be excused.
Yes, you're free to go. Next witness?
We approach Judge.
Yes. Y'all look at me, hoping I'll keep my word. I will keep my word. We have the agreement. The next witness is likely to take past 5 o'clock. It would be nice to accommodate that person since they're going to have to travel back and forth. But we've worked a full day and we have an understanding, and they won't finish by 5, and we've worked a full day. So I'm going to excuse you all for the weekend. Come back and we'll start at 8:30 Monday morning. Close your notepads. I'm going to give you a little more reminders. Keep an open mind. Fairness to these parties is that you do not form any opinions about any issues in the case at all. To hear the evidence, to hear the argument, to hear the law, and to deliberate. You have to maintain your mind in an open place so that you can receive all those appropriately and be able to discuss one another the evidence and the law as you deliberate. You can't deliberate until the conclusion of all the stages I've explained to you. Keep an open mind. Your notepads can be left in your jury room or collected by the bailiff so that they'll be secured. You don't need to worry about them. Just leave them here. You can't talk to each other about the case. You've been good and careful. We need to keep on doing that. You won't see each other till Monday anyway. So, but you're going home to family and friends to do the weekend activities. We all have a variety of things, social, religious, perhaps, family, perhaps, the different things that people do on a weekend. Chores. When you're doing that and you're having your connection with those that you come into contact with, don't talk about the case or let them talk to you about the case. I've told you exactly why that is, but let me remind you, you are the jury selected, chosen, and sworn to try this case. Only you. Only you are going to hear everything the law allows about this case in this courtroom. Nobody else. I have found even the stingiest person on the planet to be very generous with one thing, and that's their opinion when they have no responsibility at all for that opinion. I think blah, 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 blah. Well, so what? And you don't need to hear it. So just go, or something else, perhaps a little more polite so that you'll come back with your hand. Because there's some folks I know that if you went to them, you might not, it might not be pleasant. But you'll know how to handle it. Just simply keep it evermost in your mind. I can't talk about this. I can't let them talk to me about this. You know, even your loved ones, to say, I love you, but I can't do it. No independent research, no independent investigations of any sort whatsoever. You're going to hear everything that the law allows you to hear about this case. The evidence of the case is coming to you as we speak. That's what you have to base your verdict on. Nothing else can come into your awareness. And as you know, if it becomes brought to my attention or something, we'll have to stop the trial and make an investigation to be sure nothing's been done along those lines. That's not how we want to spend our time. We want to try this case. So be mindful of that. No contact with attorneys, parties, or witnesses to the case. I hope you all have a wonderful weekend. I'll see you at 8:30 Monday morning.
All right, the jury. Just watch the stuff going down.
Any issues before we retire?
Yes, Judge. I
Please
brought
be
up
seated.
during the lunch break, proposed order that was suggested by Stark involving some evidence that we'd like to look through during breaks. And I now amended that order after discussing with the defense counsel. Their complaint was it doesn't itemize what particular items. And then that's a fair issue. So what I've done is I've modified the forms that we can specifically write down what items we're looking at. So at present, there are 5 items that we would like to look at over the weekend, 4 extraction discs in the car seat, and I put those exhibit numbers on this proposed order I've shown to the defense counsel.
What do you say?
We'd like to take the iPhone 5 with us over the weekend so that we can have an opportunity to review that piece of evidence. If the state's going to be able to take pieces of evidence out of the courtroom that are already admitted in the evidence, we should have the same ability to do that. So,
And did you talk to them first?
yes, I told Mr. Evans that I wanted, I asked him if he would have a problem if we took the iPhone out. I don't think he wants me to, but my understanding is that the state already has copies of all the stuff that they put into evidence. You know, that's why we put it into evidence. That's where it is, and they've got copies they can review. I don't know that they need the original, but I mean, if the court's going to allow them to take original pieces of evidence out, the defense should have the same privilege. We'd like to take the phone.
What do you say?
Well, first of all, this is the state's evidence. This is not the defense evidence. And I certainly have no objection to the defense looking at the iPhone while it's in the custody of the clerk in the presence of law enforcement officers. My investigator would be happy to stay with them while they power up the phone and look at it here or elsewhere. That's always been an option that's been available to them from the outset. But that is the state's evidence. If they want to take their evidence out, they can prepare an order just like the one that we've prepared so that they can more orderly put together their case for presentation. I will point out to the court that the extraction discs take an awful long time to load up on the laptop. You saw that yourself, which creates a lot of technical difficulties. That's not original evidence. It's what's recovered from the actual device itself. So it's very limited. While we could work from copies of that, the fastest way to load that on the laptop for the orderly presentation of the evidence is to be able to have some time to actually put it on the laptop and mess around with it on the Mondo pad that we have upstairs at the district attorney's office. So I don't have an objection to them ultimately looking at the phone under a controlled context. They can look at any of the state's evidence in a controlled context, but it is still the state's evidence, so we'd object to them being able to take it out.
Well, I think we're mixing apples and oranges. And I want to talk about the fact that this could. I want to finish talking about what the state's requested, and I don't really see quid pro quo, et cetera, going on with this. What is your objection about what the state has offered in terms of their work?
That it is already in evidence. It is not the state's evidence. It is in evidence, which is in the possession of the court and the clerk of the court. They already have copies that they can work from. What happens if a piece of this original evidence is maybe put by a magnet or lost or damaged or who knows what? That's why we have the clerk of court maintain possession of the actual evidence which has been admitted. I just see no reason and no purpose for the state to take the original out when they've got copies of all this. We know they've got copies. They've given us copies.
Our witnesses won't be testifying from copies. They're going to be testifying from the original evidence. Therefore, it makes sense for them to be able to look at the actual discs that we're going to be playing things from and to be able to look at the other items of evidence. I mean, the only other alternative is to impose on your clerk to be involved in the process of allowing him to do this, which we don't mind doing. It's just, it's kind of a hassle for him. So we were trying to do this more as a courtesy to him because, you know, he's got a weekend too. But at the same time, if you're not willing to do that, if the court's not willing to entertain this minor issue, then I think I can take it up with Mr. Phillips and we'll make some alternative arrangements for some of that things.
I'm not going to sign the order. I think the defendant's arguments are valid, and I think there is an alternative, and I think Mr. Phillips will accommodate.
Thank you, Judge.
All right, what else for the state before we break for the day? What else for the defense?
Once the state has had an opportunity to take a look at the proposed charge and the court has had an opportunity, I'm fine if we take that up Monday morning. It doesn't have to be done now, but that's the only other thing outstanding that I'm aware of.
Well, they may be ready. I don't know. Have you all had a chance to review?
I did review it, Judge, and we don't agree to it. I think what would be fair to say is that we now stipulate to it. I don't think it's fair to say that you're overruling your ruling. We're just saying we changed our mind and we stipulate to the admission of this report, so it's admitted.
And, Judge, of course, that would not be accurate, because what happened in front of the jury was the defense tendered a piece of evidence, the state objected, and the court sustained that objection, meaning it did not go into evidence. So that's what the jury saw. They saw that I did something that the court didn't agree with and sustained the state's objection, and therefore I think it's incumbent upon the court to set that right specifically, and that's why I've used the language that I have in that proposed instruction, which says just that. I tendered a piece of evidence, the state objected, the court sustained, the court has revisited that, and will now allow it in evidence.
Well, I don't intend to do either what y'all say. Here's what we'll do. Last week during the testimony of Cobb County Police Officer Gallimore, the defense offered into evidence a copy of Officer Gallimore's police report. The court has reconsidered its ruling not allowing the exhibit into evidence. Officer Gallimore's written report is admitted into evidence as defendant's exhibit 3. I'll do that.
Thank you, Judge.
Any objection?
That's fine, Judge.
All right. Now, we can do that first thing.